Mondrad plc is a property company. Its principal activity is buying land, building private houses, and selling those houses direct to the public. 4 directors form the board. The 3 executive directors are Gina, a solicitor in charge of legal issues, Mohammed, a surveyor responsible for land purchases, and Piotr, in charge of advertising, marketing, and house sales. Sam, a retired accountant, is a non-executive director. The company is confronted by the following situations. The company recently purchased a small rectangular piece of building land for £500,000. Although the land was surrounded on 3 sides by existing developments, it appeared on visual inspection to have access to the high street. Gina dealt with the legal work necessary to complete the purchase. It now appears that a routine inspection of the title deeds would have revealed that a 4-meter strip of land runs the length of the 4th side, preventing access to the high street and making retail development impossible. The owner of this strip of land is willing to sell at a price of another £500,000. Consider the liability to the company of Gina and Mohammed. The company developed and sold a small site of townhouses. The houses were marketed and quickly sold at £150,000 each. It subsequently became clear that the houses were undervalued and would have easily sold at £155,000. While the company did not make a loss on the development, its profit was marginal rather than substantial. Consider the liability to the company of Piotr and Sam. Gina has perhaps been negligent. How does this affect her and in what capacity? What has the company lost and who is likely to offer compensation? How about Mohammed? Shouldn't he have realized the error? The duties of the directors are owed to the company, both in the common law and under the Companies Act of 2006. Duties, therefore, are not owed to individual shareholders. If the board does not initiate an action against the errant directors, a shareholder could do through a derivative claim under Section 260. The common law set a subjective standard for negligence. The Act adopts an objective one in Section 174, setting out a duty to exercise reasonable care, skill, and diligence. Subjective considerations can only add to the director's duties. It appears, therefore, that Gina has been negligent. How about Mohammed? A director can delegate, but the director retains an obligation to supervise. Further, Section 173 imposes a duty on directors to exercise independent judgment. The whole board could be culpable for the mistake in authorizing this land purchase. What happens if a director is in breach of this duty to exercise reasonable care, skill, and diligence? If loss can be established, the director is responsible to compensate the company. Remember that the company would not be able to ask for a cancellation of the purchase of the land, as third parties are not affected by any internal irregularity. In this part of the question, there seems to be a loss of corporate opportunity. Who is responsible for this? Would the company have any entitlements to compensation for any breach of duty, even if the loss is so small? Directors are under a duty to promote the success of the company under Section 172. A director of a company must act in the way she considers in good faith would be most likely to promote the success of the company for the benefit of its members as a whole. What is the meaning of company success anyway? Success is defined in commercial terms, as there is an assumption that the company is a commercial company. The directors are expected to behave in the way they consider in good faith as the most likely to promote the success by making money. As the company made a profit anyway from these transactions, it would be difficult to prove that the directors involved in the decision, and specifically Piotr, breached Section 172. With the benefit of hindsight, many decisions look wrong, but the question is whether a director was acting in good faith at the time the decision was made. Could Section 174 be used to argue that he was negligent? Again, the argument here would be based on the director falling below generally acceptable standards or performing at a lesser level than their personal ability. The question offers no information on that regard. Could we pin a breach of 174 on Sam? Would he, as a retired accountant, be in a better position to help with the patient? The weakness in the case of Sam would be that he has a non-executive role. Further, an argument based on negligence suffers from the same weaknesses as in the case of Piotr. There is no evidence that the directors did not act in good faith at the time and at the best of their ability when the decision was made. On balance, it seems that this was a bad business decision, but not an actionable breach of duty by any of the directors.